Courts all across the state of Florida have been engaging in what I've characterized as the foreclosure purge of 2014, and that is a concerted effort from courts all across the state to clear the backlog of foreclosure cases that began with 377,000 cases in June 2012. Now, the outcome of the purge so far has been monstrously effective. Here we sit with the latest reporting in April 2014 showing that backlog has been cut down to 185,000 cases. Now, the question that I continue to ask, but apparently nobody else is asking, is what happens to all of those properties that are in foreclosure? And one thing should be noted, and that is that number of foreclosure cases in a state as big as Florida with as many houses as we have is frankly not all that significant from a numbers perspective. You know, 377,000 cases in a state with as many houses as we do, even if all of those were flushed out immediately, would not be terribly significant if those cases and those foreclosures were spread all across the state and all across communities. But in fact, that's not what we find. The problem that you have with foreclosures is that the number of foreclosures are concentrated in economically depressed areas that are already suffering. And so here in the Tampa Bay area, particularly here in the St. Petersburg area, when you pull up the maps that show exactly where the foreclosure cases are pending, they're highly concentrated in areas that are already suffering economically. And then when you look in other areas, other communities, they're not nearly as concentrated. And so while we do see some data that shows that there are real estate price increases, the reality is in many areas, those economically challenged areas, we're not seeing increases. In fact, things are getting much, much worse. And at this point in time, we should talk about the data that is being reported. It's misinformation, quite frankly, when we look at data from, say, the realtors and other organizations that talk about real estate prices that are increasing. And I think the problem with that is those figures are based on a small subset of the available real estate, the available foreclosure cases. You know, if you got 100 houses that are not being used or are vacant or whatever else are up for market, and 10 of those houses sell, but those 10 houses sell for a 20 or 30% price increase, and then you try to extrapolate that data across the other 100 houses to make the proposition that there is an increase, I don't think that's relevant. I don't think that's accurate data, because if you're only focused on that 10% and ignoring the other 90%, clearly you're not coming up with relevant data that speaks to the whole market. But again, focusing on what is going to be the long-term impact of that. Across the state in courtrooms every day, as the courts are devoting more and more resources to hiring senior judges and hiring staff to flush all these cases out, what you have are dockets that are filled with bulk trials, as they call them. And that is, in any given morning, you may have 100 trials in a courtroom. And in those 100 trials, very few defendants will actually show up. So, you know, with 100 trials set, you may have 20 people at most that show up, and the other 80 are just getting flushed out as final judgments. Many people, defendants in foreclosure cases who have been interacting with banks or whatever else, have quite frankly given up. You know, they look at the house that's the subject of the foreclosure. It hasn't been taken care of over a number of years because the consumer looks at it and says, you know, why should I invest $100 to fix this leaky whatever, or why should I invest $1,000 to address a roof when the bank won't talk to me? The bank is the one that convinced me not to make a mortgage payment so that I could qualify for some kind of modification, or I did qualify for a modification, but after making payments, they turned around and ripped it out from under me, or the bank pushed me into foreclosure because while I had insurance, they turned around and slammed on a forced place insurance policy and started jamming me with tens of thousands of dollars in extra fees. You know, many consumers look at this and go, why should I participate in this more? It really is futile. And quite frankly, it's incredibly frustrating to know that in many of the cases that we experience, foreclosures were bank-induced. The bank is the one that pushed that consumer to go into foreclosure through either convincing them that they would get a modification if they stopped making payments, or forced place insurance or any of the other things. Now, obviously, there are many other consumers that fell into hard times economically, weren't able to make their payments, and struggling. The problem is, for those people that were struggling, quite frankly everybody, they were never given a fair shake by the government. And let's be clear about this. In the vast majority of cases, the person holding the cards here is not the bank. It's not Bank of America, Wells, City, Chase, or the big lenders. It's Fannie, it's Freddie, it's the Federal Housing Finance Administration. Ultimately, it's the federal government that's adopted policies that directly impact what happened to consumers. And so, frequently I'll get calls and a consumer will say, look, man, we need a principal reduction in order to make this modification make sense. And they're absolutely right. It wouldn't make any sense for a consumer to sign up for a modified loan when in signing that modification agreement, they are eliminating many of the important rights and defenses that they may have in the foreclosure. The only way that would make rational sense is if they were getting something in return. And let me be very clear and specific about this. What happens is many of the ways we win a foreclosure case is because the bank can't put together the chain from the originating lender to the 2 or 3 servicers that existed in between there, and the transfer of the note or the mortgage obligation from one party to another along the course of that loan's history, 5 or 6 years worth of different servicers and originators, and into the plaintiff that finally is suing. So many of the defenses that we have exist because the plaintiff can't put together those pieces. Well, when that consumer signs a modification, they eliminate all those defenses. So that's one of the reasons why you got to be very careful in looking at modifications. What are you getting in return? Now, if the consumer were getting some significant principal reduction or a significant increase in terms that are beneficial to the consumer, maybe that's a good decision to make. You make it from a very pragmatic perspective. Is what I'm getting in this modification good for me in the long run? Is there a good exchange there? Quite frankly, in many cases, there's not. There's just a bank getting away with all of the errors that could have been powerful defenses, and the consumer may be getting a little bit of a payment reduction, but no principal reduction at all. So the fundamental question that a consumer has to ask and face with foreclosure is, how should I resolve this foreclosure case? Should I resolve it with a short sale? Should I resolve it with a modification? Or should I take my chances going to a foreclosure sale? And in many instances, the correct answer in these cases now is to take your chances in going to trial. And a big part of the reason for that justification is the expiration of the Mortgage Debt Relief Forgiveness Act. You see, if a consumer has a loan that's, say, $300,000 on a home, and then they sign a deficiency waiver, and the bank ultimately only nets $100,000 for that property, then that consumer is stuck with a $200,000 deficiency that will be reported as 1099 income to the IRS. So what happens here is that $200,000 of principal forgiveness is calculated as income and reported to the IRS. Now, think about that for a minute. If your effective tax rate is 30% or whatever, and you got $200,000 of additional income, you may be looking at $60,000 worth of tax liability. That's incredibly profound and significant. Now, the problem is far too many consumers are utterly unaware of this. And a big reason for that is when they're negotiating directly with the bank or the bank's attorneys, they're certainly not communicating that to them. And when we're dealing with a short sale situation, that same analysis applies. Let's say that a consumer is working with a realtor, and the realtor has convinced them, hey, you should do a short sale here. The home is worth $400,000. We have an approved short sale for $200,000. And so the realtor convinces the consumer, agree to that short sale for $200,000, leaving a $200,000 deficiency with an explicit waiver of deficiency in that short sale transaction. Well, that $200,000 can very much come back to haunt the consumer when they get a 1099 tax bill and a requirement from the IRS that they pay the taxes on that $200,000 income. Now, it's a complex analysis, and quite frankly, the only person that should be really advising a consumer on the tax consequences are your accountant. Even as an attorney that has, obviously quite a bit of experience in this, my advice to my clients is, I'll talk to you generally, but specifically, you need to get good advice from your accountant. So the fundamental question for a consumer is, I'm faced with a foreclosure. It's been noticed for trial. It's been noticed for summary judgment. And I'm getting offers from the bank to resolve this. I'm either going to get a modification or a short sale. whether or not that consumer should accept that can't really be answered appropriately unless you have a detailed and sophisticated review of that case. I have many, many consumers that come to me with a case that was filed long ago and is now noticed for trial. And when we actually look at the file, we recognize that there are absolutely phenomenal defenses that I'm very confident would result in a real good outcome, maybe a win for that consumer if we go to trial. Now, unquestionably, it's a very hostile environment out there for consumers. But what we're finding is that a case that's properly defended, we can still walk away with wins. It's very important. It takes a lot of work. It's a lot of effort. But it's far better in many instances for a consumer to take that chance of a win at trial than accepting one of the other outcomes, shortcome or modification. So when you're noticed with summary judgment, you're noticed for trial, don't just fall for the easy option, modification or short sale. Take the chance to have the case reviewed and go to trial. Be willing to take that chance and go to trial to resolve the foreclosure case as a result, rather than just tucking your tail between your legs and walking away.